Hello, friends and fellow seekers. Sally the Seeker here. I am going to try something a little different in addition to what I already do, which is you never know when I'm going to show up, how many times, and that's just based on the fact that I do this on the side for mostly just for um, entertain entertainment purposes, creativity outlet, and just to connect with some of you all who have been with me. A few of you have been with me since the beginning of time, the beginning of Sally the Seeker. But I have recently found myself interested in true crime and specifically the cases and ones that I find particularly bizarre, interesting, whatever. And probably most of you will have heard of Darrell Brooks. I mean, he has been covered by multiple people. He's still being covered, and he has been convicted and sentenced. 6 consecutive life sentences, plus more than 700 additional years in prison for the Waukesha Christmas Parade Attack. And before I continue on, I'm just letting you know I don't have a degree in psychology. I don't have any legal expertise. This is clearly for entertainment purposes. I will say I do have experience in middle school teaching. And this man, Darrell Brooks, acts through this entire court process like a middle school child, except with the exception that the middle school children I dealt with did not mow over 61 people and kill 7, including an 8-year-old child. So there's the difference. But what was particularly interesting about this case, and some of y'all, like I said, may have already watched it, was the fact that he decided, I think from my understanding, first he pleaded guilty by reason of insanity, but then he had, I believe the judge said like 3 different psychiatrists come in, and the man, I will tell you right now, is not insane. And some people might think he's not intelligent, but he truly is, because he managed to kind of take charge of this courtroom with his shenanigans. But in the end, obviously, as you see, with all the years he's going to spend in prison, he wasn't that smart. But he was smarter than what people think. But like I said, what's interesting about this particular case is that he decided he was assigned 2 public defenders, and he decided that he wanted to represent himself. Usually that does not go well from prior history, although I think there are a few cases where it did bode well for the defendant. But in this case, it was a huge, colossal mistake. And the way that this man took over the courtroom, wasted time, had utter lack of respect for the court, for the witnesses. I'll share that with you if you all have not seen that yet. But so he decided that he was going to represent himself, and he is part of the sovereign citizen movement, or whatever you want to call it. He considers himself, well, he says he's sovereign, not a sovereign citizen. And so you are going to hear repeatedly, if you've not seen this already, him talk about that he does not identify by that name. He's going to talk about subject matter jurisdiction. You'll hear that over and over again. It's the same stuff. He's a broken record. And even though no matter how many times he's been told that these things don't hold up, he will repeatedly say it. He will talk about the who is the plaintiff. The plaintiff is the state of Wisconsin. So he argues that he, according to the law or his rights, he is supposed to face his accuser, which the state of Wisconsin is not a person, it's not living and breathing, it is an entity. But he will continue to ask witnesses about that. There will be other things, but the main thing I wanted to share is why it's a terrible idea to represent yourself in most cases. I wanted to share with you him going before the judge and the two public defenders he had before turning them loose, and how specific the judge was in saying that when he gives up the right to attorneys, that means he's not going to have the same, let's say, perks, benefits as the prosecution. They're going to have certain things at their hands that he won't have. And he was told this time and time again specifically, but he continues throughout this trial to complain about how it's not fair. He interrupts. It is just, I've never seen quite a show like this. And I kind of choose to kind of take it in a humorous way, although the most important thing is that these people were in Wisconsin, Waukesha, Wisconsin, on November 21st, 2021, in a Christmas parade where you're supposed to have fun. And as a result, 61 people were injured, 7 were killed, as he decided after he had a altercation with his ex-girlfriend, which is what the court concluded, or the jury, because the jury's the one who found him guilty. There is talk that perhaps this altercation with his ex-girlfriend, whom he almost ran over, or he did kind of run over and injure her, led to him having a total, meltdown anger. And he just plowed through this parade of people, mowing over people with no regard. And as you will see in some of the things I share with you, he seems to have no remorse. It's almost like he's removed himself, as if he did not do it. And throughout the whole trial, he tries to say that, he asks people, he will repeatedly ask about the tinted windows. Did you hear a horn honking? How do you know that it was me in there? You'll see it is foolishness. It's just sheer foolishness. But the saddest part is this is you can tell this is a strong, loving community. And what these people have gone through, no one deserves it. But I just thought it was so interesting. I wanted to share it with you. And like I said, you all might have seen this, but perhaps everyone is sharing it in different ways, and perhaps my perspective might be a little different from somebody else's. So, you might get something from me that you didn't get from someone else if you were as dedicated to this peculiar and very extremely horrifying and sad case. So, before I share you, because it's a very complex case, and so I'm trying to get some of, if you haven't seen it or only seen a little bit of it, but it says here that he was sentenced to life in prison without the possibility of extended supervision Wednesday. And it was back in October, November. I can't remember the date, but it's past October, November. For driving his SUV into a crowd of Christmas parade attendees in Waukesha, Wisconsin, killing 6 people. I'm sorry, it was 6 people. Killing 6 people and wounding dozens. In a clean sweep for the prosecution, a jury found Brooks 40 guilty last month on all 76 counts stemming from the attack, including 6 counts of first-degree intentional homicide with the use of a dangerous weapon, that being his mama's red SUV. He gives his, not testimony, but he does opening statement, closing statement. You can see that throughout this thing, he has no remorse for what he did. Like, again, it's almost as if he is looking out, because he'll call himself the defendant. So maybe using this sovereign citizen, and what is it? There typically is pro se, but in here he'll say it's pro per or whatever it is. As the lead prosecutor, who was a pit bull, prosecution did an excellent job. Said it was a bunch of legal mumbo jumbo. His lack of respect for the judge, the prosecution, who actually helped him, but he did not see it that way. He is one of the most entitled human beings, rude, and like I said, reminds me very much of middle school students, and maybe sometimes toddlers I have dealt with. But the only difference is they did not mow over and murder and injure all of these people. So I thought I'd kind of give you that background and then share some of the footage. So let me know if you like it. I mean, after you see some of the stuff. Like I said, I'll probably do it on Tuesdays, True Crime Tuesday. But as you've seen me, I'm kind of flighty. I'm kind of flaky. What are you going to say sometimes? But we'll see how this goes. If it's popular, there's another case that I'm very interested in. I don't know if you all have heard of it. It actually happened here in the fine state of Freaky, Florida, in Orlando, and that is the suitcase killing, where this woman zips up her boyfriend in a suitcase and allegedly allows him to smother to get to death right here in Florida. And that trial, I think, is supposed to begin sometime in January, and I might be looking at that because that's another fascinating but horrifying case. But like I said, I'm going to kind of take this one here in a humorous fashion, but really it is still with deep respect and sorrow that this grave situation happened to these poor people in this fine, strong little town of Waukesha.
Some of the sovereign citizen language in context where it is maybe not as inconsistent as it may first seem, to support what Mr. Brooks is saying he wants, and that is to represent himself in this matter.
What I hear you saying is that certainly prior to yesterday's hearing, Mr. Brooks made it very clear to you he wants to represent himself.
That's right. That's why we filed the motion to withdraw.
Has he done or said anything to you that would cause you to change your assessment of his desire?
No.
Thank you.
Yes, I'm aware of what's in the motion, yes.
Is there anything about that motion you do not understand? So let me start off again by asking you, do you wish to represent yourself in this case?
Yes, I do.
Before, I'm sorry, go ahead.
I would like to represent myself pro per.
What does that mean to you, sir? Explain to me that request.
Again, because I've already said it on record, to represent myself as a sovereign citizen.
I'm not going to make a determination, sir, whether you're a sovereign citizen or not. It's not relevant to my determination how you characterize who you are, other than you are accused of 77 counts, which I will go through momentarily, and you have the right to have an attorney represent you. That's your constitutional right. You have two very capable attorneys that have been with you from the beginning. You understand that, right?
No, I do not understand that.
What don't you understand about that, sir?
I don't understand why is a reference being made to the capableness of my attorneys. Now, I agree that they have worked tirelessly on a lot of the things in this case, and I credit them with that. I'm appreciative of that. But it also should be said that there's a lot of things that I did not understand about the proceedings in a lot of the court cases. There were things that I didn't understand why there wasn't certain motions filed. There were a lot of things that I did not understand the totality of the meaning behind. And that is what kind of led to a lot of issues. But these were issues that were being raised for a number of months. This was not just something that sprung up out of the blue. And I feel that as my attorneys, that it would be essentially their job to make me aware of things that I do not understand. So that's where a lot of the questions come into question, actually.
So let me follow that up, sir. If I allow them to withdraw, you lose their legal experience, their specialized training, right? Their education, their work as attorneys. Do you understand that?
No, I did not understand.
So if you are allowed to represent yourself in this case, sir, you will not have attorneys assisting you. If I let them withdraw, they're gone from this case. Do you understand that?
I think I will probably be better served representing myself.
So in order for me to evaluate whether that's appropriate in this case, there's certain things that I need to go through with you and on the record. Okay, do you understand that?
Yes, Your Honor.
Did you hear me tell you about the penalties for these offenses?
Yes, but I don't understand the nature of the cause of the charges.
Sir, did you hear me tell you about the penalties for these offenses just now?
I don't understand the nature and cause of the charges.
I'm not asking you that, sir. Did you hear me advise you of the penalties for hit and run resulting in death?
I don't understand.
Did you hear me tell you about the penalties for hit and run resulting in death?
I don't understand the nature and the cause of the charges.
But that's not my question, sir. So stop playing games with me right now, okay? Did you hear me tell you the penalties for hit and run resulting in death?
Doesn't mean I understand.
I'm not asking you if you understand. I'm asking you, did you hear me advise you about the penalties? Are you able to hear me right now?
Yeah.
Did you hear me advise you about the penalties for hit and run resulting in death?
I don't understand the nature and cause of the charges.
Again, sir, did you hear me right now?
I heard you right now, dude.
Did you hear me tell you the penalties? Yes or no?
Yeah, I heard.
And it's, I'm not asking if you understand. So you're the one who wants to represent yourself in this case. So I need to go through all of the penalties with you. There are 2 counts of felony bail jumping. Each one of those counts is a Class H felony, and upon conviction, you may be fined not more than $10,000 or imprisoned not more than 6 years or both. Did you hear me tell you these penalties just now?
I don't understand them.
Did you hear me?
I heard you.
There are also 2 counts of misdemeanor battery domestic abuse. So like that though.
Yeah, I heard you.
For the 6 charges of hit and run, the maximum exposure that you face for just those 6 offenses alone is 150 years. Do you understand that?
No.
Did you hear me say that though?
Yes.
For the 2 counts of felony bail jumping, the maximum for both offenses is 12 years imprisonment. Do you understand that?
No.
Did you hear me say that though?
Yes.
For the 2 Class A misdemeanors, the maximum is 18 months, meaning 9 months plus 9 months. Do you understand that?
No.
But did you hear me say that?
Yeah, I heard you.
You heard me advise you of all of these penalties. Is that right, sir?
Yes, I heard you. You not understand, but I heard you.
Sir, do you want to be represented by a lawyer in this case?
No, I do not.
Do you understand that you have a constitutional right to be represented by a lawyer in this case?
I'm aware that that is one of my rights under the Constitution, yes.
You understand that if you do not have enough money to hire your own lawyer, you may be entitled to have a lawyer appointed to represent you. You understand that?
I'm aware, yes.
I've already gone through the charges and the maximum penalties of imprisonment for all of these offenses. If you are represented by a lawyer, he or she may discover information or facts which would be helpful in your defense. A lawyer may find that you have a defense to the charge or that there are facts which may result in a lighter penalty. I want you to take this into consideration in deciding whether or not you want a lawyer to represent you. I also need you to understand that the trial will continue under the same legal rules that would apply if you had a lawyer. If you represent yourself, you will have to follow these rules. Because you are not trained in the law, this will make it hard for you to challenge the evidence presented by the state and hard for you to present any evidence that you want to present. If you decide to testify, you will be sworn as a witness and can give testimony while you are acting as a witness. You will be asked questions by the other side at that time. However, you cannot try to testify while acting as your own lawyer. Do you understand these things, sir?
No, I don't, because it sounds like pro se to me.
Because it sounds like what?
It sounds like pro se to me.
Well, there are 2 options here. Pro se means you act as your own attorney. You're self-represented. So when I talk about not having a lawyer, representing yourself, acting pro se, those are all the same. They all have the same meaning. Do you understand that?
No, I do not. My understanding that it's not the same meaning as representing yourself as pro per. And if that could be clarified for me, then it would greatly help.
Sir, under the Constitution, you have a right to have a lawyer and you have a right to self-representation. Those are the only 2 rights that I am talking about today.
I'm aware of that.
So whatever your understanding about some other hybrid fashion not what I would be proceeding under. Do you understand that?
No, I do not.
What is your expectation, sir, about proceeding on your own in this case, in this pro forma, as you have said?
I simply seek to represent myself pro per so that I can establish my sovereign citizenship.
But what does that mean as to whether you have an attorney or not to you?
Clarify what you're saying, what you're asking.
You keep repeating this phrase, is it per? Spell it for me.
Yes,
I want to make sure that I have the right words that you're using.
You want me to spell prior persona or pro per? Which one?
Tell me what you think you want to do in this case and what phrase or term that you're using and what it means to you.
Your Honor, I just stated on the record what I would like to do. I don't think.
Spell it for me.
PROPRIAPERSONA.
And what does that mean to you, sir?
It means that I am representing myself as a sovereign citizen of the United States.
Does that mean you have an attorney or not have an attorney representing you, to you?
It means that I am representing myself in all legal matters. So that would say that I am my own attorney.
Do you understand, in order for me to honor that request of yours means you must waive your right to an attorney in this case?
Can you clarify that for me?
In order for me to honor this request of you to appear pro persona as a sovereign citizen, let me back up. What you're telling me is that you want to represent yourself and you're describing it as pro persona. Fair enough? Do I have that right?
Yes, ma'am.
All right. What I hear when you say that is you want to represent yourself and exercise your right under the Constitution to be your own attorney. That's what I understand your request to be. Am I wrong in my assessment of that?
No, you are not.
In order for me to recognize your request and grant your request, you must waive your right to counsel in this case. Do you understand that?
Is it case law on that would give me clarification?
I can't give you advice, sir. I'm just asking you questions. All right?
My understanding is I don't see how that comes into play. That's why I'm asking, is it a way that can be, that part of what you're saying, just that part can be clarified to me, because that was not my understanding, that there had to be some waiver of rights and
Sir, in order for you to represent yourself, you must waive your right to an attorney.
Now, since you just broke it down that way, it's a little bit more clear. That's all I was asking.
I don't necessarily know, right, what's going on in your mind. That's why I ask a lot of questions. So do you now understand that, sir?
Yeah, I would like to waive that right to counsel. I would like to represent myself from her, as I stated this.
Part of the decision I need to make, sir, is to evaluate certain criteria. That's why I asked the questions earlier, in part about your level of education, your level of literacy, your ability to communicate in the courtroom, etc. Do you remember me asking you those questions?
Yeah, I remember you asking me that.
So another thing that I have to evaluate those, sir, because ultimately I have to make a determination that you are knowingly, intelligently, voluntarily, and deliberately making a choice to waive your right to counsel and represent yourself. And in order for me to do that, I must establish certain things, including that you understand the charges and the penalties you face. Does that all make sense so far?
Yes.
You may have a lack of understanding about the nature of the charges and may have questions regarding that. But my role here today is not so much to explain all of those nuances and explain the basis for the charges, but to make sure you understand what charges you face and the penalties for them. Do you understand the distinction?
Yeah, it makes sense to me.
All right. So I'm going to go back to these charges again, sir. Do you understand you're charged with 6 counts of intentional homicide? I'm not, and let me preface, I'm not asking you if you understand why. I'm asking you if you understand that these particular 6 charges have been filed against you.
I am aware.
And are you aware of the penalties if convicted, for each count of first-degree intentional homicide?
You said a lot of numbers, so.
Well, and I can go back to them, and I'm okay. This
No,
is
we don't
important.
need to-
So,
we don't need to do all that.
first-degree intentional homicide is a Class A felony, and upon conviction, you shall be sentenced to imprisonment in life. Do you understand that?
I'm aware.
All right. And are you aware that there's also an enhancer for use of a dangerous weapon?
I don't understand that, but I'm
Are you
aware.
aware?
I'm aware.
All right. Are you aware that if a jury finds that you committed the offense of first-degree intentional homicide by using a dangerous weapon, that maximum term of imprisonment for this felony may be increased by not more than 5 years? Essentially, it adds 5 years for each offense convicted with that question being answered by the jury, yes. Do you understand? Are you aware of that?
I'm aware.
And are you aware, sir, that you face 61 counts of first-degree reckless endangering safety use of a dangerous weapon? Are you aware that each one of those 61 felonies, upon conviction, you may be fined not more than $25,000 or in prison not more than 12.5 years or both? And are you aware that if convicted and the jury answers the question yes about using a dangerous weapon, each of those terms of imprisonment may be increased by not more than 5 years? Are you aware, sir, that you are also charged with 6 counts of hit and run resulting in death? And are you aware that each one of those Class D felonies is punishable by imprisonment up to 25 years?
You say 25?
I hope I did. If I didn't, it's 25 years. I'm reading it right from the
I probably missed it.
State of Wisconsin Circuit Court, Waukesha County. Do you see that?
I see that.
Do you see where it says State of Wisconsin plaintiff versus Darrell Brooks defendant?
Okay. This is why I'm confused. You have a lot of every document I ever got up until this point was like this, with my name in all caps.
So what are you holding up? Is that the motion to withdraw?
Well, yeah, because it's the newest.
Right. So every legal document that is filed that's considered a pleading would have a caption. The caption is the information that says what court we're in, so it's circuit court, the county, Waukesha County, and tells the court who the parties are. The parties in this case are the state of Wisconsin as the plaintiff and Darrell Brooks as the defendant. Are you aware of that, sir?
No, I'm not. I need clarification on how the state of Wisconsin can be a plaintiff, because that would essentially mean that the state of Wisconsin is the injured party. How could the state be the injured party?
Sir, I am not going to go down this path of giving you legal advice. Are you?
I'm not asking for legal advice.
Right. And I don't need
I'm
to
saying
provide.
I'm confused on how that can be. That's what I'm saying.
Well, the bottom line, sir, is the state of Wisconsin is the legal entity represented by the Waukesha County District Attorney's Office that brings charges against a defendant.
Alleged defendant.
Well, no, you're a defendant accused of committing offenses. You're not an alleged defendant. You are a defendant, but the allegations are accusations. Are you aware of that?
No.
Are you now aware of it because I just told you that?
No.
Well, we're going to start with this premise, sir, that the state of Wisconsin is the plaintiff. They are represented at the other table, whatever courtroom we are in, throughout all of the proceedings, or the vast majority of the proceedings in this case. You're aware of that, right?
No.
You're not aware that these attorneys, these people seated to your right, have been in court virtually every time that you've appeared in court?
The guy just came like the last few court dates.
So you are aware because you made some observations.
Well, the confusion with the question that you're asking is still, how can the state of Wisconsin be the plaintiff?
I'm not going to answer that question, sir.
Party?
I have a different reason for advising you, and what you need to know, what's important for my conversation with you today, is that the state of Wisconsin is represented by 3 attorneys.
Is that a judicial determination?
That is not. That's their prosecutorial discretion, sir. So but what, hold on, nope. Let me ask you the questions and tell you certain things. What I want you to know is that the 3 attorneys appearing on this case have a collective, if I did my math right, 66 years of experience as attorneys. Did you hear what I said? Yes or no?
Like 66 years of experience as attorneys. Okay.
So I'm gonna ask them a couple questions, and I want you to listen carefully. Attorney Opper.
Yes, ma'am.
Has your entire career been as a prosecutor?
Yes, ma'am, since 1991.
How many intentional homicide cases can you estimate for this court that you've been involved in?
10.
That's just before me. Is that how you took that question, or is that total?
Oh, I'm sorry, total in the course of my career.
All right, so 10 intentional homicide cases that actually went to trial or just prosecuted in general? I wasn't very clear on my question. So
Okay. I would say probably 8 of those would have gone to trial. This is a ballpark, Judge.
right. Suffice it to say, you are experienced in litigating intentional homicide cases.
Yes, ma'am.
You're also experienced in litigating reckless endangering safety charges.
Yes, ma'am, I've had many cases like that over my career.
How many trials do you think you've participated in over your 31 years?
I would estimate 200.
Attorney Basie, similar questions. You have, I believe, 27 years of experience.
I do.
All of that as a prosecutor?
Yes.
Can you estimate for the court how many trials you have been involved in?
125.
Very precise. Any of those intentional homicides?
Yes.
Any of those involve recklessly endangering safety charges?
Yes.
Now, Attorney Witchow, you're what we call the baby of the bunch. My understanding is 8 years of experience.
Yes.
All of that as a prosecutor.
Yes.
Have you been involved in an intentional homicide trial before?
No.
In addition, Mr. Brooks, first of all, did you hear the answers to the questions I just asked these attorneys?
Yeah, I heard.
I mean, you understand, sir, they have a lot of experience sitting at that table. Would that be fair to say? You also understand, though, that they have at their disposal an investigator with the Waukesha County Sheriff's Department, meaning they're assigned, that person's assigned to the district attorney's office to help them, even during a trial.
I don't understand where we're going with this.
Just want you to understand the resources that you're up against when you represent yourself.
Doesn't make me flinch one bit.
And I'm not asking you whether you flinch, I'm asking you if you understand it.
I still go back to the question I asked. I don't understand how they can represent an injured party. How can the state of Wisconsin, the corporate state of Wisconsin, be an injured party?
I'm not answering that question. Okay, this is
Or is that a judicial determination that you're not answering that question?
No, sir. This is a legitimate case, and I'm not going to make a mockery by you asking that question, because this case has been proceeding since November 23 of last year, and it's going to keep going on, whether you understand how the state can be a party or not. Do I make myself clear?
No, because the question is still there. It's still a relevant question.
I'm telling you, I'm not answering the question, and whether you understand the issue or not is not going to stop this case from going forward.
So is that a rush to judgment?
No. So I also want you to be aware that the district attorney's office has available, because the case involves witnesses from the city of Waukesha Police Department, that they will have seated at the table behind them, currently seated now, Detective Tom Casey. Are you aware of that?
I'm still going to refer back to the question.
Sir, answer my question. First of all, did you hear me ask the question? Did you hear me? Yes or no?
No.
So I'm telling you, Detective Casey is going to be their court officer throughout this case. Did you hear me say that?
How?
In addition to Detective Casey being here, the district attorney's office also has a support staff member that will be available for their use during this trial. Did you hear me say that?
I'm still not understanding how there are questions not being answered.
Sir, did you hear me tell you that right now?
Did the court hear me ask the question of
Mr.
how
Brooks.
can the state be a plaintiff?
Mr. Brooks,
Is
gotta
it
answer.
some type
I'm
of
not-
case law you can point me to?
I'm not allowed to give you legal advice, nor will I.
I'm not asking for legal advice.
The whole point of this, sir, is that I need you to be aware that many people are going to sit on the other side of the courtroom working towards presenting this case and seeking convictions on all charges. Now, seated next to you are attorneys Perry and attorney Keys. My understanding of their experience, sir, is that Attorney Perry has been practicing for 20 years. Attorney Perry, is that true?
Yes,
All of that with the public defender's office.
that's right.
You have experience both now in the trial courts and appellate courts, is that true?
Yes,
And throughout that experience, you have litigated intentional homicide cases.
I have.
Also been involved in, I would imagine, cases where the charges involve recklessly endangering safety,
Yes,
hit and run, resulting in death.
it's possible. I don't know.
Attorney Keys, my understanding is you have 12 years of experience,
Yes,
all with the public defender's office,
in criminal defense.
all in criminal defense. And you've been involved in intentional homicide cases as well.
Yes,
Suffice it to say, you and Attorney Perry have dedicated your careers to representing the rights of people accused of crimes.
Yes,
Take that job very seriously.
I do.
Attorney Perry, same thing, right?
Yes.
Mr. Brooks, did you hear me ask your attorneys about their experience as attorneys?
I'm trying to understand what is the relevance.
Sir, did you hear me ask them about their experience?
What's the relevance?
Sir, did you hear me ask them questions about their experience as attorneys? Yes or no?
What is the relevance, Your Honor?
Since you're questioning the relevance, I will presume that you heard me and understand that you are seated next to attorneys who have dedicated their careers to the representation of individuals accused of crimes, and that they're very experienced at that.
So you're assuming something that I did not say.
The other thing that I need to make sure you are aware of, sir, is what the state would have to prove in this case in terms of the elements of the offenses. I presume, but I want you to confirm that you understand the state of Wisconsin bears the burden of proof in a criminal case.
I'm not going to confirm anything until the question is answered how the state can be a plaintiff.
I'm not going to answer that question, sir.
Can it be shown to me by some type of case law?
You currently have attorneys representing you. I have not discharged them. If you have questions about legal topics, you can ask them. I'll even give you a moment. I'll step off. Give you a couple minutes, 5, whatever. If you need to ask them those questions, do you want that opportunity?
You're on the record.
I can pause.
No need to pause. Can the prosecution?
Sir, we're moving on. I understand you're not happy with the court not answering this question that you have, but I'm not going to answer it.
Well, that's essentially a rush to judgment.
I'm not rushing to any judgment, sir. My concern here is to make sure that you understand the charges you face, the penalties that are associated with them, that you're aware of all of these things, that you are aware that you as a defendant do not have to prove anything at a trial. Are you aware of that?
I can't move past the rush to judgment.
There's no rush to judgment. Did you hear me, sir?
You just assumed that I said something I didn't say.
We're going to move on.
How can we
We're moving on, sir.
How
Mr. Brooks,
can we do that, though?
we are here at your request to represent yourself. We're going to move on because your question is not relevant to that inquiry. So I'm moving on.
But it's relevant.
And you don't have to like it.
No, it's not. It's not that I don't.
We're moving
I'm
on.
fine. It's just I find it hard for me to ask a question that's not relevant, but then it's relevant for me to know the
Mr. Brooks, we're
experience
moving
of
on.
everybody
And
here.
if you have the inability to move on, then this hearing is done.
It still has to be a determination made.
Sir? I would like to
Yeah.
continue. So we need to move past this. And if you can't move past this, then I'm done.
Then I can still make the record.
Sir, do you understand that
Not.
the state of Wisconsin must prove each and every offense beyond a reasonable doubt?
No, I do not understand until my question is answered.
Sir, are you aware that
No, I am
the
not aware.
state, I didn't even ask the question. How can
I'm
you
not
answer?
aware.
Mr. Brooks, are you aware that the state must prove every element of each offense charged beyond a reasonable doubt in order for you to be convicted?
No, I'm not aware. The state still has, I'm still confused. How are they?
Right, Attorney Perry, please, we're gonna go off the record. I'm gonna take a break. I'll mute the live stream. I'll even stop it for now. I'm gonna clear the courtroom. I'm gonna give you some time to talk with Mr. Brooks. I'm not answering his question, nor am I required to answer his question, but I can't move past this if he is going to keep interrupting. He's not demonstrated thus far that he understands enough for me to even get past that to make a determination that he can waive his right to counsel.